Good afternoon. I'm Benjamin Cormos, a partner with Walsh LLP in Calgary, and it's my pleasure to introduce to you today a few subject matter experts talk today on the topic of mediation and arbitration. And now, just to introduce the panel that we have with us, I'll give a brief summary of what I do, and then we have Gary Beefus and Casey Smith. I'm an estate litigation lawyer and also a commercial litigation lawyer. I help families resolve succession and business succession disputes in the estate world, and in the business world, I help clients resolve everything from invoice disputes, collection matters, to complicated construction and engineering problems. So that's my practice. So now to turn it over to Gary Beefus to introduce himself.
Hello, I'm a litigation lawyer with Walsh. I've practiced with Walsh for 30 years, done numerous trials in all courts in Alberta and in the federal courts. And I've done appeals to the Alberta Court of Appeal, the Federal Court of Appeal, and to the Supreme Court of Canada. I've also done arbitrations. I have experience in engineering, environmental areas, prior to coming to the law, I worked for an engineering consulting firm. So I've worked with many experts in that area, both in arbitrations and in trials. I bring some experience to the table, and I've enjoyed and had the good fortune of working with many interesting clients over my career.
Thanks, Gary. And now over to Casey Smith.
Thanks, Ben. Casey Smith. I'm a lawyer in the litigation group. I also practice in employment law. And so my experience is pretty broad, also having practiced previously with Alberta Justice. And due to the nature of disputes in construction law, we tend to have a lot of contractual provisions around mediation and arbitration. And so we get to experience that quite a bit.
Always great to have your advice, and also great to have Gary's mentorship. I want to turn now to what is mediation and arbitration. So what is mediation and arbitration? Well, mediation is essentially a non-binding process where the parties can come together with the assistance of skilled mediators and try to resolve the issues that are in dispute. Where that's not successful, however, they still have the option of either going to court or going to an arbitrator to get a more expedient hearing. And arbitration, on the other hand, is a more binding process. It's typically not appealable, and it's just like having a private judge, but with a lot less of the procedures and document production and some of the other more daunting procedures that would normally apply in court. So there's flexibility in arbitration, although you will walk away with a binding resolution, an award of the arbitrator that's enforceable in court, actually. And so the courts will enter it as an order of the Court of Queen's Bench, and it can be enforced just as though a judge had issued it. So we would recommend you consider using mediation and/or arbitration in this difficult time to keep your matters moving forward. I'll have some specific practitioner questions that So Gary, what approach do you bring to your practice in litigation matters?
My overall approach, and it may sound like a simplification, but it's something that for me is a primary ethic, which I always test against every step I take, and that is to be an advocate for my client and to make sure that at all times the interest of my client is put forward first above all else. Everything has to be tested against that. Mm-hmm. We as lawyers do have obligations to the court, and we have obligations to other counsel that are set out in the rules, but it's important not to get lost in all of the things we do, that every step we take to test it against what is in the client's best interest. That's my focus in everything I do.
Thank you, Gary. What can clients do to prepare their cases for you to advance in a mediation or arbitration?
For me, the largest hurdle that I face as a lawyer is having the clients put together a complete set of the records they have that are relevant to the matter at hand. Very early in the process. It is keep your documents and your records organized. And I say documents, I realize that we live in a world now where everything's maintained electronically, but still, documents need to be organized in a way that's logical, that everything's kept together. And I'm talking everything from emails to agreements to drawings to notes, everything. That is the most useful thing that a client can do and bring to the table early on with lawyers, so we can understand what we're dealing with and what the evidence is going to look like.
Thanks, Gary. And I think that's going to help our viewers as well when they come to us for assistance in advancing the matter. I'll turn now to Casey. Casey, how do you see the future of employment law disputes and dispute resolution evolving in Alberta?
Well, I think employment disputes are really well suited, actually, to alternative dispute resolution. In our practice, we act for both employers and employees. And certainly from a cost standpoint, if the matter can be resolved expeditiously, this is going to be a huge benefit. You know, if you're an employee, obviously you've just been terminated, you've lost your stream of income. And so if you can get a decision, either in arbitration or through mediation, you get that money in your pocket now, which will be really helpful. Likewise, as employers, you've just let an employee go for one reason or another, good or bad, and probably don't want to spend the next 2+ years in the courts. So mediation or arbitration conducted early in the process can help tie everything up and just allow the parties to move on. If you can come to a resolution outside of the court process, it's probably going to be both quicker and less expensive.
Thank you, Casey. And I think that's going to also help our viewers today understand how they can come to you for their employment matters and move them forward quickly and cost effectively. What are some ways in which you have effectively used mediation and arbitration to assist your clients?
Yeah, I mean, as I said before, some of my practice is construction law. And so there's a long history there with decisions that people in the construction industry were not happy with the decisions that were coming out of the court. And so now what you see in most of the contracts is that there are mandatory provisions where they are essentially forced to go through a process, usually that starts with negotiation and mediation, and then ultimately leads to arbitration. It forces the parties to put their cards on the table and know what the case that they have to meet is or against. It may not happen directly at that mediation, but usually, you know, a week or two after that, things have cooled down. It gives a good opportunity to think reasonably about the case and see what the likelihood of being successful or actually defending the case may be.
Perfect.
Arbitration, as you mentioned, can be a little bit different because there's a decision maker, but there's a few benefits there. Like you said, it can be done usually a lot quicker. You have more control over the process, and you can at least choose or agree to the arbitrator who's going to hear the case, which we don't have that luxury when we go to court.
Thank you, Casey. That's excellent, and that gives our viewers a little bit more information and insight into the process, but also specifically how it is that you would advance their matter, and I appreciate that. Thanks, Casey, Gary, for joining us. And to wrap up, I'd like to thank each of you for participating, and I'd like to invite our viewers to contact us at 403-267-8400 or go on our website, www.walshlaw.ca to discuss engaging us to assist with your mediation or arbitration matters, or to ask us any questions you might have. Thanks for watching, and we hope to hear from you soon. Take good care.